Good morning, everyone. Present, I, Ashabri Basu along with Bhavya Birla and Balram, 50 students representing Symbiosis Law School Noida. From our experience in 5 years of law school, internship experiences, and the various competitions that we have attended, we have identified certain gaps in the legal system, along with we will be providing them to you along with possible legal solutions. I am focusing mainly on the forefront of the elderlies and access to justice. Bhavya Birla will be focusing on digitalization efforts in the court system, and Balram will be talking about mediation in corporate insolvency proceedings. Moving on to the access to justice and elderlies. At the current system, in 2026, we are expecting around 17.3 crore elderlies in India. India currently is at 71st country among 96 countries in providing access to justice to elderlies. Therefore, a well-reformed outlook is required for providing elderly justice by the year of 2047. For this, I propose a threefold scheme. Firstly is with regard to finances, which includes pension. In the current situation, if I take for illustration the Indira Gandhi National Pension Yojana scheme, it provides only rupees 200 up to 79 years of age and rupees 500 over 80 years of age for per month to all elderly. Comparing it with the minimum wage scheme which is established in this country in 2022, the minimum wage that was available to a country to a person is 178 rupees per day for any person. So this clearly means that the amount of pension available to a senior citizen is very well less than the minimum wage that is available to a person. This was also clearly highlighted in the case of Ashwini Kumar versus Union of India, which reached the Supreme Court in 2018, and a report was to be formalized for the same. However, due to the pandemic situation, a report has not been formalized and the pension scheme has not been revised. Secondly, is with respect to web-based learning, every senior citizen should have access to a web application through which they can say whatever they want to have their access to justice, and they can be connected to various volunteers. This is also in accordance with the UNESCO digital literacy scheme, and since we are living in the age of digital literacy, the decade of digital literacy from 21 to 2030. So this digital literacy and web application would take time. So in the alternative, an elder helpline could be established. I understand that an elder helpline of 14567 has already been established pan-India. However, in reality, it is only working in 6 states, the states of Telangana, Tamil Nadu, Madhya Pradesh, Rajasthan, Karnataka, and UP. And in 2022, it was also established in the state of Andhra Pradesh. However, this is not pan-India and it needs to establish pan-India because although we may not have internet services, everyone has phone services and the elders need to reach the same. Since we are talking about 2047 and 2047 elders will be an integral part of this country. Thirdly is regard to implementation. We have various acts like the Maintenance and Welfare of Senior Citizens Act 2007. The NALSA and the State Legal Service Authority wants to provide mandatory legal services to all elders in the country. However, there is not proper implementation of the same. There was also discussions about implementation the state commissions and national commissions along with an appellate body for elderly law and elderly crimes alone. However, that has not been formalized for the same, and therefore that can be taken into account. With these proposals, I would yield the floor to Bhavya Birla to talk about the digitalization efforts. Thank you.
Good morning, sir. I will be addressing the second and the fourth goal, as well as inclusivity of people. Firstly, just to establish the points that I will be forwarding, over the last decade, we have gone from 7.4 percentage of internet penetration to over 50% in 2021. Digitalization is the goal with which we are going forward, and digitalization is the future of the country. Almost every government service has gone digital, whether it be the benefit delivery system or any other government access or access to any other government initiative. So, since digital is the future, access to justice can also be given to the people through digital means. But this has to be done in a manner that is that is accepting of the ground realities of what India is today. Considering we are an extremely diverse country, accessibility to justice can only come through understanding and incorporating that diversity into the system that we propose. We propose that that can be done through, firstly, inculcating vernacular languages in the digital system that we propose. Vernacular languages are something that is extremely looked over. Like the E-Codes Committee, in their reports, in their three reports, even in the latest phase 3 report, have talked about as to how inculcation of vernacular languages is important towards making an accessible justice system. But there is not much done in terms of implementing the same, whether we see the high court websites or whether we see any applications that have been given to citizens. Vernacular languages are often looked are a second step, not the first primary step. So accessibility to justice can only come through when we understand, or when we communicate properly towards the people through to the litigants. So they need to understand in their own languages what the court wants from them, or what they can ask from the court. Only then will they be more inclined towards accessing justice for themselves when they need it. The second point that I would like to forward is something that is building of infrastructure. Over the last As I had stated, over the last decade, we have increased from 7.4 to 50% internet penetration in the country. However, we need to also understand that the digital divide exists. There is a digital divide in terms of access to internet in the urban and rural setting, as well as this divide is intersectional. So there is also a gender divide. So, as an illustration, the an urban woman and a rural woman, there is a difference between their accessibility to the justice system and their accessibility to these internet resources. Considering digitalization is something that the government of India has been working over, we need to factor in these realities as well and mitigate these problems through, firstly, giving them digital training, as well as maintaining a parallel system of sorts. Considering more than half of India is still not on the internet, and the people that are, there is a significant portion of which that do not understand how to use internet resources, do not understand how to use digital resources, primarily due to them being in English. And considering vernacular languages are not given the importance that they should be, we need to understand that we firstly need to train them in vernacular languages, as well as inculcate a parallel system that firstly teaches them how to access digital resources, as well as to make it easier for them so that they can access justice. The last point that I would like to forward before yielding the time to Balram is that any system that is dependent on digitalization has to inculcate principles of security and privacy. Over the last year alone, CERT.in, that is the Computer Emergency Response Team, had reported that India had faced a 300% rise in terms of cyber attacks, in terms of ransomware, as well as cyber attacks to critical information infrastructure. Taking that in mind, we need to understand that any system that is relying on digitalization needs to be protected. So, as a suggestion, SLS Noida would like to forward that in the years to come, in this year or the next year, the PDP bill, that is the Personal Data Protection Bill, will be passed. Any digitalization effort that has to come forth should abide by the PDP bill, as well as inculcate state-of-the-art encryption software, as well as access to this software should be limited to the limited stakeholders in the system. That will be all. I shall yield my remaining time to Balram.
Good afternoon, Chair, and all the other panelists. So, my suggestion is that we should imbue mediation into corporate insolvency process. So, as we know that mediation is something which allows the parties to come up with out-of-box solutions, for which we are here today. So, there is a possibility that resolution plan which is arrived. So, I'll just everybody knows about the stats, but uh, a brief stat which I would like to present is that as of 2020, the average time which was taken for adjudication under proceed of adjudication petition of CIRP under the Insolvency Code, which is also a very recent addition into our legal arena. It was one earlier. It was 180 days, and with an extension with a judgment of the Honorable Supreme Court, 270 days. So what now is that a thing which was to be done in just 180 days takes 270 days, and courts are not every time solution. So when we imagine or when we think about India 2047, then we also can imbue certain off-court mechanisms where disputes can be adjudicated, not in the sense they are being done in courts. So parties can be urged towards mediation during the CIRP, especially when it is evident that a substantial portion of the litigation is due to lack of collaboration between the parties. Because, of course, when there is litigation, there's no collaboration. So this is important when company is a company which is going under insolvency is viable, and the partners are also intending to, if not work together, then at least they are intending to part away. And we already possess the necessary legal infrastructure. We don't have to create anything. We don't have to do anything new. So there's Section 89 of the CPC, which permits and encourages courts uh, to encourage resolution of disputes through ADR methods. And then there's Companies Act of 2013, which specifies the establishment of a mediation and conciliation panel of experts to whom NCLT may refer. So what the idea is, and India is not the first jurisdiction in the world to face this problem. Every jurisdictions across the globe are facing problems of pendency, and so I'll take example of Singapore. How Singapore evolved itself in 2017. There was a new act in Singapore which is known as the Mediation Act, and they created a resolution mechanism panel under SIAC, which is their International Commercial Court of Justice. And and
Yeah.
that is
Kindly wrap it up, conclude your suggestion now, because we have 12 more law schools to speak their views.
the last sentence which I want to make. This is my conclusion, that we can by imbuing mediation into the consultancy process, we can do this thing in a very short span of time, and mediation can be used in other other facets of legal adjudication as well. So this will reduce a lot of time in our education process. Thank you very much.
But will this, your suggestion, will this entail amendment in the current IBC?
No, sir. No, sir. That is what I'm suggesting. That if we see the Companies Act 2013, it specifies the establishment of mediation and conciliation panel of experts to whom the NCLT can refer.
So it
And
is actually not being practiced. Provisions are there, but it is not being applied.
yes, sir.
Is this the point you are making?
I am trying to
Okay.
say that provisions are there, but they are not seen with this angle of ADR.
Not
Because,
seen in this. Okay.
yes, sir.
Yeah. Thank you.
Thank you so much.
Thank you so much.